Consumer Counterpoint, your vidcast talking about consumer-related issues in the class action world, trends we're seeing, ways to mitigate against risk. I'm Christine Argentine, one of your hosts. I work at Cypher Shaw in our Chicago office in the litigation group.
And I'm Paul Yovanik. I also work in the Chicago office in the litigation group and focus on class action litigation. So today we're going to be talking about arbitration. Obviously there's a lot to talk about with respect to arbitrations as a way to avoid being in court, class actions, avoiding the kind of the publicity and the exposure. But I think it's a lot to discuss today about why arbitration and also how arbitration can be enforceable. And I think that's kind of the more important part.
Yeah, I mean, I think this is a topic that lots of companies face and think about when they're dealing with consumer issues, especially if they've dealt with a consumer class action.
Sure.
And some benefits of arbitration, right, are you have a process that is meant to be more expedited. It's private. Right? I
think that's a big part of what clients really like is privacy. I mean, you don't want to be the next one on one of the big legal media outlets getting hit with, a massive judgment or decision.
That's right. And so when we're talking to our clients about whether or not they want an arbitration provision and the things that go along with that, right? An arbitration provision means that you likely have a jury waiver, obviously, because you're not in court. You have a class action waiver, right? Arbitrations are individual claims that are litigated with an arbitrator on an individual basis. And so those cases are less, the exposure is significantly less.
Right.
So they're easier to fight or take a stance on, and the risk isn't there that if you lose, you're losing to the tune of millions or billions of dollars.
Sure. Yeah, and it's interesting, we talk about arbitrations, and I think the plaintiff's bar might have a different take sometimes. I mean, we've discussed in, settlement discussions with plaintiff's counsel about, with arbitrations where it's, I have 4 of these arbitrations. I might lose one, I might win one, and they're all private, and so that in itself can be a bit of a headache when thinking about this sometimes, because it's like, you win one, you think about like class actions, like you defeat class certification, you might, now all of a sudden that case is going away because now there is that legal binding decision as opposed to an arbitration, a private decision where it's like can't really use that in another case.
Yeah, and I think that is something that I didn't think a whole lot about until we started seeing these cases where the case law wasn't really developed yet.
Yeah, and California, SIPA. Yeah.
That's right, and we on the defense side were very much looking for and anxious for decisions to come down. And like you said, if you're in arbitration, those decisions aren't public, and you can't use them with any sort of presidential value.
Yeah, so it's almost like in those types of cases, like the SIPA cases in California and arbitration, it kind of cut both ways, where it's like, all right, well, the case law is not as developed, and where it might be an advantage to us a little bit to get creative with the arguments. I think some of the plaintiffs' bar was like, well, we can also take multiple shots, and we might win some, we might lose some, but like, when we win, we win.
That's right.
And, we're litigating same issue, same type of, claims. So it's not like the plaintiff's bar is, redoing everything for every case. So it can be interesting that way.
Yeah. And I think, so there's a real thought process around, more so than I think there was before, about do you even want an arbitration provision? Like, is that something that you as a company want to enforce, and what are the pros and what are the cons of that?
Sure.
And something that we're not going to talk about today, but I'm sure we'll talk about in another episode, is this whole trend towards mass arbitration.
Right. That's a whole nother
right. And
discussion.
So that is another reason why companies are rethinking about whether or not they even want arbitration provisions, or it is the class action now the more efficient, more cost-effective way to go about litigating issues that are trending or very popular.
Right. No, it's crazy to think that we're now at the point where we're thinking maybe class action might make more sense at times.
Right. So let's go to the point where we want an arbitration provision, right? So now the question becomes, how do we make sure that our arbitration provision is enforceable?
Right.
And we were talking about this a little bit earlier about, well, when you have in the employment context, right, you have an employee sign an arbitration provision as part of their
Yeah,
onboarding.
it's very robust. It's right in
right.
front of you. There's no question whether you saw it, you agreed, you signed that you did it. But now we're talking about consumers visiting a website or making a purchase, or and you can't just clients don't just want to have like, oh, here's a lengthy arbitration agreement. You have to scroll all the way down to the bottom every time you make a purchase or every time you visit a website. So obviously that's where I think a lot of us struggle with this.
Yeah, and so and let's set the baseline of there's no point in having the arbitration provision if it's not enforceable.
Yeah,
right. So and courts have really dug in on that question over the last several years of like, what does it take for an arbitration provision on a website or through a purchase to be enforceable? Because the key to enforcing your arbitration provision is consent, right? That consumer has to know that there is an arbitration provision that they are consenting to in whatever action is they're taking.
Right. No, and so we've seen kind of this more strict approach, or not strict approach, but more of just an active approach of like the enforceability, looking at this, like we said, in the consumer context. And so, what are some of the mechanisms or some of the ways that we've seen these arbitration provisions be enforceable? And then I guess on the other side of it, like where have we seen some of the pitfalls?
Yeah. So there's a lot of different ways that courts look at this, right? And they look at it through what's called click wrap agreements, browse wrap agreements, sign up agreements, scroll wrap agreements, right? And so let me go through kind of all of those, right? Yeah. So the browse wrap agreement, right, is when someone it's not something that they are specifically agreeing to through like a check mark. It's basically the arbitration provision is in the terms and conditions, and the consumer has to essentially browse the website to find that and know. Okay. Those have been generally held unenforceable, right? The idea that
this idea of like go find it.
That's right. Or the idea that you have a hyperlink at the bottom of your webpage, which most consumer sites do, that has a link to the terms and conditions. Courts say it's not fair to say that consumer has to go scroll down, click on that link, find out what the terms and conditions are to using that website before they use it, and then be bound by whatever's in there.
Yes, but it's not to say that you can't have that link at the bottom of the website. Sure. It's more just you also need to have that link somewhere else, kind of like more right in your face.
Yeah. So yes, it has to be like reasonably conspicuous. Right. Yeah. If you want to do this browse wrap. Now, a click wrap is when you have kind of a statement at checkout or in your cookie banner that says, by clicking this box, I agree to the terms and conditions.
Yeah, and there's the link again, the same link that we have at the bottom of the website, right there. So you have to click. You have arguably the opportunity to click that link,
right,
to figure out whether or not you agree to those terms.
Correct. And so it's the key there, though, is that checkbox, right? I, as a consumer, am affirmatively checking that box saying, yep, right, I agree. And so those, as you can imagine, are generally found enforceable. Right?
Or at very least, you had the opportunity to review that agreement, whether or not a consumer actually did.
In that instance, the consumer does have to click for it to be enforceable.
Click the box.
Correct.
But the link is, I guess it comes down to you had the opportunity to click that. The same way you had the opportunity in the employment context to review what you signed before signed it, because it's right there. It's right in front of you.
That's right. You as the company don't have to prove that they actually read the arbitration provision, but if they click that box, they are on the hook.
It wasn't buried at the bottom of the website. There was a box right there that basically prompted you to click this link if you want to, but either way, you're agreeing to the terms, whether you choose to read it or not.
Correct. So let's talk about what the grayer area is, right? The when you have not a true browse wrap, not a true click wrap, but you have these kind of other forms, the scroll wrap, the sign up wrap, where basically you have a statement to the consumer that says, by using this website, you agree to our terms and conditions, but they don't have to check anything, right? notifies
And there's
them of
maybe
that.
maybe no link to the terms and conditions, it just references terms and conditions.
Right. So courts have been looking at those with a lot more scrutiny, those types of agreements, and saying, is the consumer put on inquiry notice as to what they're agreeing
Like
to?
enough
Is it
transparency
reasonable?
to reasonably achieve consent.
Yeah. And so when we look at that, what courts are really looking at is a couple different things, right? They're looking at how obvious is it to the consumer? How transparent is it to the consumer that is what they're agreeing to with whatever action they're taking, whether it's a purchase, whether it's continuing to use the website, whether it's signing up for marketing messages. How obvious is that to them that I, as the court, am going to say, you were on notice that there was an arbitration provision, or that you were agreeing to the terms of use at the time you took this action. Right. So how do we make sure a consumer is on notice? So one of the things that courts really look at is like the font size and the placement of that font, right? So you can't include that statement of you agree to, by using this website, you agree to terms and conditions. It can't be smaller than the rest of the font. You can't hide
You can't
it.
just bury it in size 6 font when everything else is 12 and 14.
That's right.
Yep.
Similarly, it shouldn't be a lighter color, right? Harder to read than anything else on the page.
Because it almost gives that feeling that, like, are not necessarily hiding, but like that lack of transparency. You have no problem discussing or labeling everything else on the webpage in a darker font, but like this thing, we kind of, it comes off as we kind of don't want you to see it.
Right.
Yeah.
Right. So you want to make sure it's the same, or better yet, it stands out from the rest of whatever language there is. So you don't want to bury it in a paragraph, right? You want kind of a standalone statement that says, by using this website, or by making this purchase, or by signing up for marketing messages, I agree to the terms and conditions.
Right.
Or the terms of use. Like you were talking about earlier, right? You also want to make sure that those terms of use, that privacy policy, wherever that arbitration provision lives, is hyperlinked. Yeah. Right? And hyperlinked in a way that the consumer knows that it's hyperlinked.
Yeah, so you get that blue, that's that common blue link. I mean, you think about arguing this before the court, there was a link right in front of the user before they purchased or before they, whatever they were accessing on the website, and they had the opportunity to click it. Right. We made it clear it was there. Right. I mean, that is transparency. Yeah. At its best.
And something you just said is another thing that's really important, is right in front of the user. Yeah. Right? So that placement of that statement and those links is very important. Yeah. Right? So you think about when you're checking out, right, with a purchase.
You're putting your credit card information, you're putting every information, all of a sudden, like how far down does a user have to scroll down to see, oh, you're bound by these terms of use? Yeah. And it's like, if it's too far down, I can see the argument of like, yeah, but if you click submit your purchase, but it's a little bit further down, how does a user ever get to really see it?
That's right. And so what courts have said is, we don't want you to have to scroll at all, right? They shouldn't have to scroll to see that statement.
So it should be in that first part before even scrolling begins, right there. Yeah.
And it should be above whatever action button you need to click. So if your action button says submit or purchase, right, that line saying by making this purchase you agree to the terms of use needs to be above that button.
So I guess if you had the kind of more lengthy checkout page and you did have to scroll, as long as that purchase or order or complete your transaction is the last thing the user sees and everything else before that, the customer arguably okay.
I think that is okay, right? Because in order for that user to make that purchase, to take that action that they want to take, they have to get to that button. Exactly. So long as you make that statement reasonably available to them and know that, okay, I'm reading through,
they will get to that before they can do their purchase. Yes.
That's right. You know, another little nuance there is, right, you want the language to match. right? So if your statement says by clicking continue, you agree to the terms of
Right.
use, but your button says submit, arguably that's confusing.
Right.
And that's, not sufficient. And so it's interesting because you really want to think about all of these things in website design that maybe don't get thought about, because people are more concerned about the design itself,
Well,
right?
and
How
that goes back to
attractive
what
is
you
this to
were,
a consumer, and
to like what you were just talking about too, of just with website design, updating the website. Let's change the the continue or the purchase button, but it used to be continue or it used to be a second page, but that language of by clicking continue, it's no longer there. So
Right.
it's like website design needs to be working with other units of the business to
Right.
figure out, okay, are we tracking, does this all track?
Yeah. I mean, the other thing you want to think about too in this space is, where do I have these disclosures? And it might be multiple places.
Sure.
Because there are different types of claims that might be brought that you want to enforce that arbitration provision
Exactly.
over. And so just because you have that language at the purchase page, doesn't mean it's enforceable against someone who is just browsing your website.
Or someone who's enters their phone number to get
Right.
discounts and codes and whatever it might be. So now we're talking about TCPA.
Right.
Doesn't mean I purchased anything. It means that I might, but I'll continue to get discount codes and notifications of
Right.
product availability.
Right. Or for instance, we've seen, the wiretapping claims in chat functions.
Sure.
Right. And so you want to think about, okay, does that chat function, when someone accesses the chat function, do I have the disclosure there? By continuing to engage with this chat function, you agree to our privacy policy and our terms of service.
Yeah.
What about the cookie banner?
Yep.
Right? What about someone who is just browsing our website? Now, ordinarily, 5 years ago, you wouldn't have had to really worry about that. But today, with SIPA, with the tracking technology websites, if you want to enforce an arbitration provision to try to mitigate the risks and exposures of those cases, that disclosure, that consent should be in your cookie banner, right? By continuing to use this website, you agree to our terms and conditions.
Yeah, because you
our
can
terms of
imagine
use.
just the biggest pitfall would be, we have this, this click box, at the time of purchase, but as the plaintiff's attorney will argue, my client didn't purchase anything, but
Right.
they went on the website, they got notifications, they received text messages, they never received notice of arbitration.
Right, exactly. And so again, if arbitration is a tool that you want available to you, you got to make sure it's enforceable.
Yeah.
And so, we're getting a little over on time here. So as we said, we'll talk about mass arbitrations later, and whether you want arbitrations anymore or what those considerations are. But if you do want it, right, you've got to follow these really specific rules to make sure that is enforceable, and that it is a tool that you have in your box to try to avoid class actions or jury trials or whatever it is that you want to enforce as part of those terms of use.
Absolutely. Well, this was very helpful. Thank you so much, Christine.
Yep.